What a pleasure it is to be the moderator for Richard Gergel and his book, Unexampled Courage, The Blinding of Sergeant Isaac Woodard and the Awakening of President Harry S. Truman and Judge J. Watties Waring. Judge Gergel is a United States District Court judge who presides in the courthouse in Charleston, South Carolina. He earned undergraduate degrees and law degrees from Duke University. Also with his wife, who I was fortunate to meet, Dr. Belinda Gergel. He's the author of In Pursuit of the Tree of Life, A History of the Early Jews of Columbia, South Carolina. Now, although somewhat of a cause célèbre at the time, with well-known persons such as Orson Welles and many others in support, and a speaking tour by Sergeant Woodard arranged by the NAACP, this story appears to have been essentially forgotten. And yet it was a major factor in President Harry Truman's order desegregating the armed services and the Supreme Court's eventual decision in Brown versus Board of Education. Fortunately, sitting in the same federal courthouse as Judge Watties Waring, United States District Court Judge Richard Gergel unearthed this amazing and monumental story. He has presented it in an informative and moving manner that reads like a novel. I was riveted from the outset and could not put it down. It is my pleasure and an honor to present to you United States District Court Judge Richard Gergel, the author of Unexampled Courage.
Well, it is such a great privilege to be here in Martha's Vineyard. I mentioned to folks who were with us yesterday on our wonderful panel on social justice how great it has been to be in this special place of people who, it's like a full-time adult learning program, right? I mean, you folks are amazing and you love books, and we all love books. So Belinda and I have just thoroughly enjoyed being here. With the danger of leaving people out, let me just identify a couple of you just so special to us. My wonderful editor, Sarah Crichton, is here. Sarah, wave. She is both my publisher and my editor, and she has just was fabulous. My chief judge of the Fourth Circuit Court of Appeals, Roger Gregory, is here. Roger, wave. Who's been just a great leader of our court. And the legendary Vernon Jordan is here. Thank you, Mr. Jordan, for being here. When I assumed the bench in August of 2010, actually it's 9 years ago tomorrow, I came to the Charleston Federal Courthouse and was aware that in an earlier era, there was a largely forgotten, courageous civil rights judge, J. Watties Waring, the most renowned and the earliest of the great Southern courageous civil rights judges. And I wanted to know more about this man who seemed to be in history and to popular memory to be something of an enigma. And the issue that fascinated me was, how did this Charleston patrician, this son of Charleston, become this civil rights visionary? And as I launched on this inquiry to figure out how that happened, the story of Unexampled Courage emerged, which I share with you now. As the clock struck 7 p.m. on August 14, 1945, President Harry S. Truman assembled the White House press corps in the Oval Office. He had a momentous announcement. Hours earlier, the Japanese government had unconditionally surrendered, bringing an end at last to World War II. The reporters spontaneously burst into applause and then raced for the door to share this historic announcement with the rest of the nation. Thousands gathered in Lafayette Square across from the White House in celebration. And soon there were calls, "We want Truman, we want Truman." The president came into the north portico of the White House to deliver a few remarks. "This is a great day for free governments in the world," Truman announced. "This is the day that fascism and police government ceases in the world. The great task ahead is to restore peace and to bring free government to the world. But beneath this veneer of America's grand self-image stood, as the bastion of freedom and liberty, was a stark reality. African Americans residing in the old Confederacy lived in a twilight world between slavery and freedom. They no longer had masters, but they did not enjoy the rights of a free people. Black Southerners were routinely denied the right to vote, segregated physically from the dominant white society as a matter of law, and relegated to the margins of American prosperity. Racial violence and lynchings festered just beneath the surface, ready to explode at any moment. And this is a flag known as the lynching flag. And it flew from the national office of the NAACP in Manhattan the morning after each lynching in America. And in the first half of the 20th century, that it was a common sight in downtown New York. Black Americans living in other regions of the country had their own challenges. As the nearly 900,000 black veterans returned home after the end of World War II, they quickly realized that little had changed, and they began demanding their rightful place in America's free government. Seen from today's perspective, the American triumph over Jim Crow segregation and disenfranchisement might seem to have been inevitable, the collapse of morally indefensible practices wholly inconsistent with the United States Constitution. But in 1945, with black Southerners almost entirely disenfranchised, white-dominated Southern state governments resolutely committed to the racial status quo, and the federal government largely a passive bystander. There was no obvious path to resolving this great American dilemma. Something had to be done, but what and by whom? My book, Unexampled Courage, details the long overlooked story of the beating and blinding of Sergeant Isaac Woodard, a battlefield-decorated African-American soldier, by the police chief of Batesburg, South Carolina, on the day of his discharge from the military and while still in his dress uniform, and the transformative impact of this incident on President Harry Truman and United States District Judge J. Wadis Waring of Charleston, South Carolina. Horrified and inspired by the injustice of this brutal event, President Truman would launch a civil rights program culminating in the ending of segregation in the armed forces of the United States. And Judge Waring would issue landmark civil rights decisions, including his great 1951 dissent in Briggs v. Elliott, which would become the model for Brown versus Board of Education just 3 years later. Late on the afternoon of February 12, 1946, Isaac Woodard boarded a Greyhound bus in Augusta, Georgia, after discharge from hours earlier from the nearby Camp Gordon, and was traveling to Columbia, South Carolina, and then another 30 miles or so unto his home in Winnsboro, South Carolina, where he was to rendezvous with his wife after several years of separation while he was in military service. During one of the frequent stops along the way, Woodard approached the white bus driver with a simple request. Could he step off the bus to relieve himself? At that time, interstate buses did not have restrooms, and Greyhound drivers were instructed to accommodate such requests. Instead, the bus driver cursed Woodard, telling him, "I ain't got time to wait," and ordered him to return to his seat. To the apparent astonishment of the bus driver, Woodard cursed him back and told him, "Talk to me like I'm talking to you. I am a man just like you." The stunned bus driver told Woodard to go ahead, but at the next stop in Batesburg, South Carolina, the bus driver, now no longer concerned with staying on schedule, departed his bus in search of a police officer to have Woodard removed from the bus and arrested. Woodard soon found himself confronted by the police chief of Batesburg, South Carolina, Linwood Shull, who responded to Woodard's efforts to explain himself by striking him over the head with a blackjack and escorting Woodard off to the town jail. On the way, Woodard was repeatedly beaten with Shull's blackjack, ultimately driving the end of the baton into both of Woodard's eyes. The sergeant was then thrown in a semi-conscious state into the jail cell for the night. When he awoke the next morning, he realized he could not see. Later that morning, Woodard was taken to the town court, and he was convicted of drunk and disorderly conduct. Accounts of the Woodard beating and blinding were reported in the black press and received nationwide attention when Orson Welles focused on the incident in his weekly national radio program on ABC Radio. Mass meetings were soon organized in black communities across the nation to protest Woodard's treatment, including a benefit concert in New York City, headed by Joe Louis, then the reigning heavyweight champion of the world, and featuring such luminaries as Count Basie, Cab Calloway, and Nat King Cole. Of course, that's Joe Louis here to your left and Isaac Woodard in the middle. 23,000 people attended the benefit concert sponsored by Joe Louis in New York. Meanwhile, other black veterans returning to their homes in the rural South did not get the attention as they confronted other ugly racial incidents, including several racially inspired murders. No state prosecuted those involved in any of these incidents. On September 19, 1946, a delegation of civil rights leaders met with President Truman in the White House, deeply distressed by this wave of racial violence. Prior to the meeting, Truman's staff advised him that despite the president's desire to address these concerns, there was little he could do as a practical matter as president to address these incidents. Criminal prosecutions by the federal government for civil rights violations were fraught with problems. The most notable was all-white juries in the South because juror rolls were drawn from voter rolls and African Americans were disenfranchised. Further, Congress was under the control of powerful Southern committee chairs who determined to block even the most modest civil rights legislation. As the meeting opened, the civil rights leaders urged Truman to call Congress back into special session to address this spreading violence against returning African American veterans. The president expressed sympathy, but lamented there was little he could do because there was not public support for new civil rights legislation. Leading the group was Walter White, the executive secretary of the NAACP, and Truman's most loyal supporter in the civil rights community. And in this picture, he is depicted to the right, immediate right of President Truman. Walter White is largely forgotten today, but in the 1930s, 40s, and into the early 50s, he was really the most important civil rights leader in America. It was apparent to Mr. White that the president did not appreciate the gravity of the situation. White changed the discussion by sharing with Truman in detail the blinding of Isaac Woodard. As the tragic story unfolded, Truman sat riveted and became visibly agitated with the idea that a uniformed and decorated American soldier had been so cruelly treated. Abandoning the advice of his staff, Truman declared, "My God, I had no idea it was as terrible as that. We have got to do something." The following day, Truman wrote his Attorney General, Tom Clark, and shared with him the story of the blinding of Isaac Woodard, noting that the police officer had deliberately put out Woodard's eyes. Truman made it clear that the time for federal action had now arrived. He further indicated he intended to appoint the first presidential committee on civil rights to propose a new agenda to address America's serious racial problems. 3 business days after Truman's letter was delivered to the Attorney General, the Department of Justice announced the prosecution of Batesburg Police Chief Linwood Shull in the Federal District Court in South Carolina for the deprivation of the civil rights of Isaac Woodard. Meanwhile, the Department of Justice prepared the necessary documents to organize the first presidential committee on civil rights. Truman charged his committee in his first meeting on January 15, 1947, to be bold and to attack the root causes of America's deep-seated racial problems. He held the Civil Rights Committee's first meeting in the Cabinet Room to emphasize the importance of its work. In less than a year, the Truman Civil Rights Committee issued a landmark report titled "To Secure These Rights," which graphically detailed America's profound racial challenges and proposed groundbreaking policies and legislation, including the ending of segregation in the armed forces of the United States. Truman fully embraced the proposals of his Civil Rights Committee, and on July 26, 1948, in the midst of a presidential election, he issued Executive Order 9981, mandating the end of segregation in America's armed forces. The successful desegregation of the military marked the beginning of the end of Jim Crow in America. And this article with the headline, "President Truman Wipes Out Segregation in Armed Forces," is from an African-American newspaper, the Chicago Defender. And my son, noting the article, said, "Look what's on the lower right. Posse bent on lynching searches woods for prey." That was America in 1946. In 1947. The Justice Department's efforts to prosecute Linwood Shull in the federal district court in Columbia, South Carolina, produced in the short term a predictable result. An all-white jury acquitted the police chief after only 28 minutes of deliberations. The case was tried before United States District Judge J. Wadis Waring, a Charleston patrician whose father was a Confederate veteran. Yet his father fought for the Confederacy in the Civil War, and multiple generations of his ancestors were slaveholders. Prior to the trial, Judge Waring was skeptical about the federal government's prosecution of a local police officer, but his views changed when he heard the highly credible testimony of the blinded sergeant, who described his arrest and vicious beating at the hands of Chief Shull. As Shull supporters cheered his acquittal, few noticed that Judge Waring's wife, Elizabeth, who had attended the trial, left the back of the courtroom in tears. Judge Waring joined his wife later that evening, and both were traumatized by the trial over which he had just presided. The Shull trial forced the judge and his wife to stare directly into the Southern racial abyss, a view which would forever transform both of them. Waring would later describe the Shull trial as his personal baptism of fire and his Michigan-born wife's baptism in racial prejudice. The Warings returned home to Charleston after the Shull trial, resolved to learn more about the issues of race and justice, which the Warings had previously thought little about. These were not subjects that could be openly discussed among white Charlestonians of that era. The Warings decided to undertake their own self-directed study. Each evening after dinner, Elizabeth would read a portion of a selected work out loud to allow the judge to rest his eyes after a day of handling his judicial duties. The couple would then discuss what they had read, often while driving around Charleston in the evening, a favorite pastime. People ask me, well, what did they read? Well, they read some of these may be familiar from college. They read W.J. Cash, Mind of the South, and then Gunnar Myrdal's The American Dilemma. Gunnar Myrdal's American Dilemma was a Carnegie-funded study immediately after World War II on race in America. It was, Gunnar Myrdal was a Swiss sociologist and economist, and he was asked to head this study because he was not he would not be limited by his views of American racial issues. Many renowned scholars, including Dr. Kenneth Clark and Ralph Bunche, participated as researchers in that project. The book was 1,400 pages long, amazingly candid discussion of racial issues in America. After the Warings completed that book, there was no turning back. As Judge Waring's new views on race and justice emerged, George Elmore, a black businessman, filed suit in federal district court in Columbia in 1947, challenging the South Carolina Democratic Party's all-white primary. Elmore was represented by Thurgood Marshall, the 39-year-old chief counsel of the NAACP, who was already developing a reputation of almost legendary proportions as a skilled litigator and legal strategist. South Carolina's political leaders were united in their determination to preserve the white primary, notwithstanding clear Supreme Court precedent holding white primaries unconstitutional. Judge Waring understood that any decision recognizing the right of minority citizens to vote would produce an intensely hostile and possibly violent public reaction. But Waring concluded that the choice was either, quote, to be entirely governed by the doctrine of white supremacy or to be a federal judge and decide the law, end quote. On July 12, 1947, Judge Waring issued his decision in Elmore v. Rice, declaring the white primary unconstitutional. Waring ended his order by declaring, quote, it is time for South Carolina to rejoin the Union and to adopt the American way of conducting elections. That was not advice well taken in some quarters. The groundbreaking nature of the Elmore decision was immediately appreciated by the leadership of the NAACP. In a private note to Thurgood Marshall, William Hastie, who would later be appointed America's first black federal judge, stated, quote, I have read the South Carolina opinion 3 times, and I still don't believe it. Thurgood, in many respects, I think this is your greatest legal achievement. But the segregationists would not give up. Soon a new party rule was adopted, allowing blacks to vote in the party primary, so long as they pledged their support to racial segregation. Surprise, a new lawsuit was filed, and Judge Waring summoned the entire 93 members of the Democratic Party's executive committee to his courtroom in Charleston. He denounced their efforts to defy his earlier ruling and explained that a federal judge faced with contempt could impose a fine or a jail sentence. He wanted those present to know that if there were further violations, there would be no fines. Thereafter, African Americans by the thousands registered to vote in South Carolina. The response of South Carolina's white supremacists was thunderous. Death threats, written and oral, were constant. A cross was burned in the Warings' yard, and bricks were thrown through their living room window. Time magazine described Waring as the man they loved to hate, but also noted he was proving to be a person of cool courage. If the purpose of the unprecedented vilification of Watus Waring was intended to cower him, it did not work. Instead, he continued his study and reflection on race and justice in America and became convinced that the foundation of Jim Crow segregation, the Supreme Court's 1896 decision in Plessy v. Ferguson, was legally, historically, and morally wrong. Waring, then approaching 70 years of age and likely retirement, resolved to play a role in overturning the separate but equal doctrine. Waring developed a plan to place a school desegregation case under the docket of the United States Supreme Court, firmly convinced that a majority of justices would overturn Plessy if they directly confronted the issue. He noted on his trial docket a case from Clarendon County, South Carolina, Briggs v. Elliott, which sought to equalize the facilities in the district's profoundly unequal black and white schools, a classic Plessy claim. When the plaintiff's attorney, Thurgood Marshall, appeared at the Charleston courthouse on November 17, 1950, for a pretrial conference for his case to begin in just a few days, he was ushered into he was told that the judge wanted to see him in his office alone. After being ushered into the judge's office and the door closed, Waring told Marshall, "Don't bring me another separate but equal case. Bring me a frontal attack on segregation." Marshall responded, "Judge, this is on our agenda, but it's just not tonight. We don't think this is the case. We don't think this is the time." Waring was unpersuaded, telling Marshall, "This is the case. This is the time." This dramatic exchange with Waring placed Marshall on the horns of a great strategic and moral dilemma. On one hand, Marshall had faithfully followed the incrementalist approach of his mentor and predecessor, Charles Hamilton Houston, of meticulously preparing each case and building one precedent carefully on top of another, never trying to get ahead of the United States Supreme Court. On the other hand, here was a judge he deeply respected, telling him the time had come to confront racial segregation, root and branch. A few minutes after this encounter, Waring convened the pretrial conference in Briggs and publicly pressed Marshall on whether he was now prepared to challenge the constitutionality of public school segregation. Marshall stated that he was and agreed to dismiss his pending lawsuit and refiled Briggs v. Elliott as the first frontal attack on public school segregation in American history. Since the new Briggs case challenged the constitutionality of state-mandated public school segregation, a three-judge panel was appointed to hear the case, which included Judge Waring. As the newly filed Briggs case was tried, Briggs case was tried in the Charleston Federal Courthouse in May 1951. In prior years, civil rights cases in the South were sparsely attended by members of the black community, lest they be identified as members of the NAACP or challengers to the racial status quo. But on the morning of May 28, 1951, as the sun rose in Charleston, African Americans lined up at the federal courthouse and down Broad Street as far as the eye could see, hoping to observe what many thought might be the most important case in American history. Judge Waring observed the massive crowd from his office window, later describing the scene as a breath of freedom. And the wonderful artist Jonathan Green has painted this image of the opening day of the trial of Briggs v. Elliott with Judge Waring standing in the window looking out, and the title of the beautiful work of art is Breath of Freedom. Those in attendance in the courtroom were not disappointed by the performance of Thurgood Marshall and his trial team. This included the testimony of Dr. Kenneth Clark, a social psychologist who had done groundbreaking research on the effects of segregation on black children using black and white dolls. The crowd was also entertained by Marshall's devastating cross-examination of the state's key witness, whose last name was ironically Crow. Many joke that Marshall, quote, sure loves to eat crow, and one observer referencing the state's renowned lead attorney, Bob Figg, Mr. Figg got his law degree when he finished school, but he just got his baccalaureate address from Thurgood Marshall. Predictably, a two-person majority of the panel ruled that South Carolina's laws mandating segregated schools were lawful under the Plessy Doctrine. But Waring, fully aware he was writing a dissent for the ages, wrote an elegant and brilliant attack on the foundations of segregation in America. He concluded by finding that segregation in education can never produce equality, and it is an evil that must be eradicated. Segregation in education adopted and practiced in the state of South Carolina must go, and go now. Segregation is per se inequality. Waring also praised the Briggs plaintiffs, who he was fully aware had suffered severe retaliation for their participation in the case, including the loss of jobs, calling in of loans, and random acts of intimidation and violence. Judge Waring stated that the plaintiffs had shown, quote, unexampled courage in bringing and presenting this cause in the face of long-established and age-old way of life in which the state of South Carolina has adopted and practiced and lived in since and as a result of the institution of human slavery, end quote. Waring's dissent was the first challenge to government-mandated segregation by a federal judge since Justice John Harlan Marshall's great dissent in Plessy 55 years earlier. Some have asked, how could Judge Waring, a United States District Judge, presume to overrule an existing United States Supreme Court precedent, Plessy v. Ferguson? Waring did not believe he was doing that. The year prior to his great dissent, the Supreme Court decided three important cases, one involving a separate but not equal law school in Texas, Sweat v. Painter, another involving a graduate student in the University of Oklahoma, George McLaurin, who was allowed to attend the graduate school but had to sit outside the classroom. That was an exhibit before the U.S. Supreme Court. And a third involving a challenge to segregated dining cars on interstate trains, Henderson versus United States. In all three cases, the plaintiffs won in unanimous decisions. Some commentators asserted that these civil rights victories represented a further whittling away of the Plessy Doctrine. But Judge Waring, reading these cases together, concluded they stood for the proposition that separate could never be equal. Waring viewed his dissent as stating explicitly what the Supreme Court had already ruled implicitly. In early 1952, some 6 months after his great dissent, Waring announced his retirement as a federal judge and moved to New York City, exhausted by his ostracism in Charleston. Waring followed closely later school desegregation cases from Virginia, Delaware, and Kansas, all which were consolidated before the United States Supreme Court with Briggs v. Elliott under the name Brown versus Board of Education. And all the other school desegregation cases involving 14 different judges, only Waitist Waring concluded that public school segregation, even if the facilities were equal, violated the 14th Amendment of the United States Constitution. On May 17, 1954, the Supreme Court handed down unanimously its landmark decision in Brown versus Board of Education. The court explicitly cast aside the separate but equal doctrine and adopted the per se rule that all government-mandated public school segregation was unconstitutional, first advanced by Waring in his Briggs dissent. Judge Waring was always philosophical about what he called the unpleasant repercussions of his civil rights decisions. In an oral history late in life, Waring observed, "Taking the whole thing in balance, I think I'm enormously fortunate because you don't often in life have the opportunity to do something you really think is good. I think a great stroke of fortune came down my alley. The other penalties don't amount to anything. They're offset what I think is a really important contribution to the history of our country." A little over a year ago, as I completed Unexampled Courage, I visited the town of Batesburg and retraced the fateful path of Isaac Woodard from the bus stop where he was removed from the Greyhound bus and arrested to the storefront around the corner where he was beaten and blinded, and the location up the street where the town jail and court once stood. Joining me on this solemn walk was the mayor of Batesburg and the town attorney, both of whom had only recently learned of the Woodard incident from me. On June 1, 2018, the town attorney filed a motion in town court to reopen the case of the town of Batesburg versus Isaac Woodard to overturn his criminal conviction. The motion was granted, expunging Woodard's conviction. And several months ago, the town of Batesburg dedicated an historic marker candidly telling the story of the blinding of Isaac Woodard. Members of Sergeant Woodard's family traveled from New York for the ceremony, and the mayor publicly apologized on behalf of the town for the tragic events of the fateful evening, February 12, 1946. Unexampled Courage is a story that deserves to be told, with all of its pathos, its brutality, and its redemption of the American system of justice. Thank you very much.
Well, that was pretty amazing. Doesn't leave me much time, and I want to have time for some of you to ask questions. So I'm going to be very pointed in this. Linwood Schull was prosecuted for a civil rights violation in the United States District Court. And of course, he was quickly acquitted by an all-white jury. We see today, I mean, it was, as you described, civil rights prosecutions were extremely rare at that time in the South. Well, we see today that prosecutions of police officers, even in the federal courts, are still rare. This is so despite what seems like so many obviously provable cases, such as Eric Garner's, which, unlike Sergeant Woodard's, was captured on video. And his death at the hands of a police officer occurred in the North, in New York City. So, Judge Gergel, has anything really changed in the last 70 years?
Well, things have certainly changed. You know, I felt like for a while I was living in the year 1946. You know, as I was writing the book, I was immersed in this era. And things are very different in many ways, and some things are the same. And sometimes when you write about a piece of history and remote in time, you don't sort of engender the kind of a political factualism you get when you talk about things in current times, and perhaps my book will contribute in its own small way to understanding this problem. I won't comment about current cases because on my docket and Judge Gregory's docket, we have these cases all the time and we're dealing with them. I will simply comment that my great colleague David Norton just handled the prosecution of the officer who shot Walter Scott in the back in North Charleston, and he received a 20-year sentence, which the Fourth Circuit recently affirmed. So I think we're on this path, but there's a lot of more work to be done, no question about it.
One quick question. In many ways, this story concerns the personal journey of one man who, in a very short period of time, adopted views seemingly inconsistent with his past actions and words. In fact, you describe him, quote, as conventional and never questioning the status quo, did not question racial segregation or black disenfranchisement. In your exploration of Judge Waring, were you able to discern clues in his background that foretold his re-examination of his own views on race?
Well, I describe in the book, it's a very good question, Irv. I describe in the book that there are multiple views about race among white Southerners in public life. No one questioned segregation or disenfranchisement, or you were out of public life. I mean, it was basically the segregationists tolerated no dissent. Any white person who expressed such opinions was viewed as having an existential threat to white society. So there's nothing that you can't find anybody in public life who did that, basically. They're very rare, and they exited public life as soon as they voiced
it. Was that his personal views, rather than going along with the program in order to get ahead politically?
It's a good question. But what I point out is there are different views among whites. There were some more moderate than others. They described themselves as Southern liberals, and a Southern liberal was someone who sort of felt like the teachers ought to be paid the same. They shouldn't be unequal. They basically believed in Plessy. But the majority view was separate and unequal. That was what the real practice was. Judge Waring probably fell into the former category. Something, obviously jarred him out of this comfort and lack of reflection that was right around him. I mean, Charleston was one of the most segregated cities in America. You couldn't not recognize the situation. But this Woodard incident just jarred him in a way, and his wife, in a way out of their complacency, and made them examine and say, something's going on here. And eventually they came to view themselves as the only people cited in a colony of blind people. I mean, they really came to view themselves that way. And it's interesting. There are other Southern progressives of this era who had their own awakening. My good friend, Dr. Patricia Sullivan, has done the biography of Virginia Durr, a great civil rights leader of Alabama, who just said she was raised a racist, and she had an awakening in her life. So these Southerners coming of age, these racial awakenings definitely occurred. So I think, I don't want to make too much of it. Charleston was never a big follower of Pitchfork Ben Tillman, the virulent racist who dominated South Carolina politics. Charleston they were more moderate than that, but I wouldn't make too much of that. I really think these experiences as a federal judge presiding over these cases impacted him in a profound way. Okay,
now I'm going to ask you one last question, because I know there's a lot of lawyers in this courtroom who are probably thinking the same thing.
Ex parte communication.
Correct. It's Judge Waring not only recommended to Thurgood Marshall that he drop the case based on separate but equal, but also attack it directly, but he also gave him advice on how to do it and how to fashion the lawsuit.
You could almost say he directed him.
Right. So the question that I have is, can you comment on these motivations and apparently a violation of judicial ethics? And does it happen today?
It does not happen today, and nobody would get close enough to us to do it. Things were much more informal in that era than today. That's number one. Number two, Judge Waring was plowing a path no one had ever done before. He was becoming the first of the great civil rights judges of the South. And he didn't get everything just right. He didn't. This is one of the things he didn't quite get right.
A lot of people think he got it exactly right.
Well, he got it. But let me say this. Sometimes I'll have an issue in front of me, and I think the lawyers should address some issue, not before us. I won't do it ex parte. I will say in a hearing, has anyone addressed the First Amendment issue here? Same effect. I mean, I'm doing it, I'm not doing it ex parte, because I know if I don't raise it, somebody on appeal may say, well, why didn't you address this issue legitimately? So I don't think there's anything wrong with that. He clearly didn't do it the right way. But, I thought I was going to tell the story. I was going to tell the story as I knew it. And they sometimes maybe the Brown versus Board of Education is like sausage. You don't really know how we got there. There are a lot of stories and myths around Brown, and because it was such an incredible departure for the court, and probably, I think most consensus, the most important case in American history.
Well, thanks. We have time for some questions. There are mics up here.
Come to the mic.
Please,
Yes, sir. You can come to the mic if you want.
Mr. Schwader has a question.
Yes. Talk right into it.
Can you hear me?
Yes.
Thank you very much for that inspiring talk. There was a rather famous dissent in Plessy versus Ferguson in 1896 by
Justice Harlan,
which you didn't mention in your talk, and I'm just wondering.
Oh, I mentioned it. I said it was the first talk since the Great Dissent.
My question is, to what extent was that the inspiration for Waring's dissent? Because you played a great deal of emphasis on the importance of his dissent for Brown versus Board, but I think I came into this thinking that it was Harlan's dissent, which was the model for Brown versus Board of Education.
Well, I don't think you could. I don't think you could even think about the 14th Amendment at all without thinking about Harlan's great dissent. I mean, it would be the framing of the issue. Waring was really worked hard. Judge Waring was a pack rat. He kept all his notes, kept all his bench notes. I had access to all of that. And he worked on the language in which he was going to describe. He was going to describe the holding in the case, and he came up with the phrase, "Segregation is per se inequality." He wrote it he was trying to come up with his own phrase that captured what he was trying to do. I would say I can't imagine him not being inspired by Harlan, but I didn't see a lot of evidence that he didn't quote Harlan, for instance, in the dissent.
We have another question over here.
Yes, sir.
Okay. I was wondering if the sergeant, if he ever got his sight back again after he was beaten.
That is a great question. He did not. Let me talk a little bit about Sergeant Woodard's life. That's a common question I get on the road. Sergeant Woodard was initially, as Irv mentioned, really quite a celebrity. I mean, in the late 40s, he traveled. He had a speaking tour. He had huge crowds. And then he quickly faded into obscurity. When he was blinded, he had been out of the Army for 5 hours. They took the view he did not have a service-related disability. So he got a measly pension. He could not possibly live on it, and he struggled for some years trying to sustain himself. He worked ran a newsstand in Manhattan, lower Manhattan. We all seen blind people do that. He ran that for a while. In 1961, Congress changed the law that said until the serviceman returns home, he's still in service. And then Sergeant Woodard got his full benefit. I got to give credit to the NAACP. They never gave up on him on this, and were behind this change. And then he was more financially secure thereafter. He owned a home. He raised 2 children. He cared for his elderly parents. He was the head of a household. There was a wonderful interview with him by a social worker from the VA in 1964, and it talked about how shrewd he was and how proud he was of being able, despite his disability, to be the head of his family. So I'll tell you one tragic part of this. He never knew his effect on President Truman and Judge Waring. He never knew his effect. And the family, I've come to know the Woodard family very well, and that is a sadness that he never knew the impact that he had on really the future of this country.
Wow. We have time for one last question.
Yeah, yes, the U.S. Senate recently confirmed at least 2 judges who refused to express their support for Brown v. Board. Can you comment on that? And they're joining the district court. with
Yeah,
lifetime appointments. Can you comment on
there's a lot of gamesmanship associated with this judicial process, and that's the recent fashion among some not to recognize Brown. I just can't imagine, just like the reference, are you critical of Harlan's dissent? I mean, how could you be critical of Brown and uphold the modern view of the American Constitution? So anyone who called me for advice, and no one does, I would tell them, embrace Brown, right?
Thank you.
Thank you
so
very much.